morning, ladies and gentlemen of the jury. My name is Abigail Brannon, and I represent Carol Brezenski in this matter before you today. As we look at the events of today, you're going to hear facts, witness testimony, and a variety of information. And as you do, I would like you to process all of that information with the concept in mind of personal responsibility. In this situation today, the system broke down, and a good employee, my client, Carol Brezenski, paid the price. And in this instance, we are asking PUDS to take personal responsibility for the breakdowns that happened within its company, and request that you find that an innocent employee, Ms. Brezenski, not pay the price for the company's mistakes. There are 3 issues before you today. And within these issues, we will ask you to find, number 1, that the policy concerning attendance and tardiness implemented by Mr. Wexler at PUDS was not reasonable. Number 2, we will ask you to find that this policy was not effectively communicated to the employees. And 3, we will ask you to find that Carol Brezenski was not terminated for just cause. To address the first issue, the policy was not reasonable. PUDS had a long-standing history of employee honesty and employees being honest about when they were late and when they needed to make up time and taking care of it themselves. Now, if PUDS wanted to put a new policy in place, obviously they can do that. But to do so, they must implement a policy that is reasonable and that is reasonably communicated to the employees in order to allow the employees to follow this policy. The policy implemented by Mr. Wexler was unduly complicated. It had a number of steps and layers and people that needed to talk with other people when one was late. If PUDS would like to implement such a complicated policy, then they need to effectively communicate this policy to their employees. For example, when the policy was implemented, Mr. Wexler simply made an announcement at the warehouse. This announcement was conveying the mere bare bones of the policy. Our position today is that this policy was complicated enough that a warehouse presentation, along with the mere posting of the policy, was simply not an effective way to communicate in a completely new direction for the company to go, and in a fashion that was very complicated. And it was unreasonable for the company to expect the employees to understand the policy. As for the third issue, Ms. Brezenski was not terminated for just cause. As we will look at Ms. Brezenski's various violations, she incurred 4 violations, and after her 4th one, she was terminated by Pick-It-Up Delivery Services. But, ladies and gentlemen of the jury, as testimony will show, these violations occurred not only because Ms. Brezenski was late due to family obligations, but because there was a breakdown in the communication at PUDS concerning this policy. For example, the first violation, Brezenski did not report her tardiness to Ashley Dover, the lead supervisor for the union at PUDS. But when Dover spoke with Brezenski about it, she told Brezenski not to worry about it, and Brezenski made up the time at the end of the day. So, as for this first violation, a supervisor told Ms. Brezenski not to worry about it. The third violation, when Brezenski was late because of her spouse's illness, Brezenski reported it to the lead worker, again, Ashley Dover. Dover was required to report the second violation to the managing supervisor, L.T. Marino, but she did not. Again, this was not a breakdown on the part of the employee, Ms. Brezenski, but a breakdown within the PUDS corporation itself. Finally, for the fourth violation, Brezenski again reported her tardiness to Ashley Dover, and discussed that it would be difficult for her to make up the time within the required amount of days allowed by the policy. Dover assured her that this would not be a problem and not to worry about it. After Dover's assurances, Ms. Brezenski was terminated from PUDS. Ladies and gentlemen, we will have testimony today discussing Ms. Brezenski's excellent work record, and we ask that you weigh her excellent work record against the breakdown in policy of the implementation of this policy at PUDS, and as you weigh whether or not Brezenski was, in fact, terminated for just cause. In her 14 years with PUDS, there have been a number of descriptors used to describe Brezenski's performance. These descriptors are such as outstanding, satisfactory, extraordinarily hard worker, and an excellent and dedicated employee. On Brezenski's most recent performance appraisal before her termination, she was commended for having an excellent attitude and personal character, excellent technical knowledge, and possessing analytical ability and judgment that meets all expectations. Ladies and gentlemen of the jury, we ask today that you find three things: that the policy was not reasonable, that it was not adequately communicated to the PUDS employees, and that Carol Brezenski was not fired for just cause.